Welcome everyone. I'm Lloyd Kopenbarger, and I'm going to be welcoming you to this edition of the 2025 Kopenbarger Client Seminar. But before I do that, let me introduce you to the most important person in my life. Honey, would you stand up and let everybody take a look at this beautiful lady? Now, everybody here is in for a treat today because we're unveiling what I call the next generation of attorneys. These are attorneys that we've been training in our office for several years, and they've reached a point where we feel like they're as good or better than us old hands. And so we're going to let you have the opportunity to judge that, and I'm afraid you'll vote us out. But that'll be okay if you do. Without any further delay, though, let me introduce to you some of the staff we have. And first of all, some of you know me. I've reached the point in the firm, which is kind of hard on my ego, where sometimes when I'm walking out in the reception area, there'll be people out there and they'll say, "Who are you?" and that will reduce your ego a little bit when you're the founding partner. But that's a good thing. Larry Kopenbarger, you know, he's the best attorney I've ever produced. Victoria Raymond is going to be introduced to you in an additional way today, but she also is one of the people that I'm proudest of. I had a hand in her initial training as a brand new attorney for the first, 4 years? And I can say without hesitation that she's one of the best I've ever had the privilege to have a part in a mentorship of. Mark Krause is an attorney who has some experience primarily in estate litigation, but I'm shifting him over into estate planning to work with my clients and other clients, because I want all my clients to have another attorney to know if something were to happen to me. Now, I'm not going to retire, but who knows when the good Lord's going to say, "You had enough here and I'm taking you home." And I don't want any of my clients left unprotected when that time comes. And so Mark is the person that I'm working with, and many of you will be in meetings where Mark will be there with me, and the purpose of that is for you to get acquainted with Mark. And it doesn't mean I'm quitting, it doesn't mean that I'm not going to be helping you in the future. It just means out of an abundance of caution. At this point in my life, I want to make sure the people God has entrusted to me are protected when I'm no longer here to do it for them. Sonny Boren, I don't think is here today. She had COVID again. This is a terrible thing that's been inflicted on us, and I've had it 4 times, and I don't know how many times Sonny's had it now. Catherine Grout is an attorney who works in our... Catherine, would you stand up? Catherine works in our small business area, and we're very pleased to have her working in that area, helping us in that area of practice. Most of you know James Kosaroff. James is one of the attorneys in the firm that I'm proudest of. But like me, the years have passed. And he said he's going to work another 6 or 7 years. I suspect it'll be longer than that. But let me tell you a little bit about James, for those of you who don't know. James and Larry came to me right out of law school. James had gone to Northern California and had worked up there with a firm. We had sent him some business to help us with up in the northern part of the state, and I was impressed with the young man. And so I challenged him to become part of the firm. I realized with the number of people we were helping with living trusts that the time would come someday when the few trust administrations we had to do would become a raging stream as those of us went through the process of life and the process came to an end for the people who created these trusts. During his time with me, James has created what I believe to be one of the best trust administration departments in the United States. Certainly, it's one of the best here in California. And in that interim, James has gotten his master's degree in tax and law, which is a big deal. He also is a certified specialist in trust, probate, and estate planning law, which is a big deal. And he has trained a fantastic staff to work under him. And there is no part of our firm that's more difficult than trust administration, because there is no way to approach the loss of a loved one for a family that is happy. And so when you're in a position of trying to help people who are suffering that enormous loss, it takes a special person and a special quality of character to be able to do that. And even then, sometimes it's not successful because that loss is overwhelming. I know, I've gone through it. I lost my brother, I lost both of my parents, and you never get over it, and when it immediately happens, it's overwhelming. And we understand that. And so James is the face of our firm in that area. His staff is the face of our firm in that area. Mark O'Brien is an attorney who is being trained probably at some point in time to take James's place. And Mark is a phenomenal trust administration attorney. You'll be hearing from you later today. Megan Wilson is also in that area of trust administration, has a phenomenal ability to relate to people who are suffering loss. Elaine Alston is an area that we're just now stepping into, and we're getting ready to get into it in a more complete way, and that is the litigation area of the law. While my brother was living, we relied on his firm to represent us in cases where we had to go to court because of something that some other attorney did in a trust, and we weren't able to solve it because the trust wasn't done properly. Now we have that ability within the firm. Elaine Alston had worked with my brother for about 20 years. When he passed, I approached Elaine and she agreed to come and join our firm. Stan Hutchinson, how many of you here are Stan Hutchinson's clients? Several of you. We were privileged to meet Stan several years ago, and we arranged to acquire Stan's clients. Stan's philosophy of practice, the people he worked with, seemed to me to be a perfect fit for the people our firm is privileged to be able to serve. And so we acquired that firm. Stan is now cutting back almost completely, phasing himself out, but having him there in the firm this last few years has been an absolute delight. And for those of you who are his clients, we will try to continue to provide you the quality of service that you came to expect to understand and possibly exceed. Chris Carroll, you're going to meet him a little later in the day when we talk about a program that we're introducing. He's the CEO of Copenbarger & Copenbarger. I don't handle the administrative tasks of the firm anymore. About 15 years ago, Chris came into our orbit. I hired him, and he has done a phenomenal job of helping organize our firm. We have about 10 offices around the state, and keeping that running smoothly is a real challenge. And particularly with some of the innovations that we're making in the firm. We just created a new system called Clio that for these younger attorneys is heaven on earth, for us older people is hell on earth. So, but he's managing to integrate those into the system, and that'll provide a much better service to you as our clients. So those are the people that you're going to be meeting today. I want to take this time at this point to introduce a very important lady to you. I told you we'd be introducing her a little bit later. And this is Victoria Raymond. Victoria is being made a partner as of today. Victoria, thank you for what you've done for the firm up to this point, and I look forward to seeing your future as it unfolds before you.
Thank you, Lloyd.
God bless you. Now, I think, as always, I've way overstayed my welcome on this part of the program. So at this point, let me turn it over to Mark Krause, and Mark will tell you what the program is going to consist of today. Mark.
Thank you very much. One more round of applause for Victoria. Congratulations. And as Lloyd was touching on, he covered all our attorneys and our officer, Chris. Up here, in addition to those folks, are all our wonderful staff that we as attorneys absolutely rely on every day to make us look good and make sure we're not caught with our pants down and everything looks good. In addition to our wonderful staff, as Lloyd mentioned, we do have offices all throughout Northern and Southern California for your convenience. And quick look at today's agenda. If you refer, you should have everything hopefully in those packets in front of you. What I would recommend is that you, if you wouldn't mind, follow along in those packets. And any questions, we're going to kind of be shooting a bunch of information at you with kind of like a fire hose. So it's going to be a lot to take in. So I just recommend any questions, anything you want to sort of dive deeper into later, maybe just take notes in that packet. And if you schedule a time, we can dive deeper later into those things. And you can also find us at breaks and things like that. That's the second half of today's agenda. And what I'm going to be covering with you today is the foundations of estate planning. So basically just covering the basics, the essentials of estate planning. I'll give you a second to get those packets open. So of course, by the essentials and the basics of estate planning, we're talking about things like your advanced healthcare directive, your durable power of attorney for financial, your trust, wills, and I'm also going to be going into the things we're trying to avoid with estate planning, like conservatorships and the dirtiest word we know, which is probates. We really do not like that word. So the first estate planning document I'm going to talk to you about is Advanced Healthcare Directive. Hopefully most of us have an Advanced Healthcare Directive. Show of hands, people. Hopefully good. Everybody needs one. An Advanced Healthcare Directive, the important things it does, first of all, how many of us know what HIPAA is? You're familiar with HIPAA? So the first important thing it does, it gives us an exemption, gives someone an exemption from HIPAA so they can find out medical information about you. Otherwise, no one necessarily has the right to find out any of your medical information. You might think that a spouse has an automatic exemption. Not true. The second thing it does is it allows you to put wishes in place about your health care and certain end-of-life issues. It allows you to put them in a document ahead of time. And then the third thing it does, it puts someone accountable for making sure those wishes are followed, and it gives somebody the right to make healthcare decisions when you're not able to. So who needs one? Everyone over the age of 18. Another thing, you might think that parents of adult children might have some kind of automatic exemption from HIPAA or might be able to make decisions for you. Not true. If you have a child, as soon as they turn 18, we strongly recommend that they have their own advanced healthcare directive so that someone is able to access their medical information if they're hospitalized or in some kind of condition where they're not able to make their own decision and be able to make decisions for them. Kaiser has recently given some of our clients some issues. They want their own special language as to when the document becomes effective. So as usual, rather than trying to fight them and cause an issue, we just want and need the documents to work for our clients. So what we've done is we've just gone ahead and adopted the language that Kaiser wanted for all our new healthcare directives. And if you do happen to have Kaiser and you have a pre-existing healthcare directive, we can easily add that language in as a brief addendum. If you'd like to talk to us about that, it's pretty simple and easy to do, and we can take care of that for you. Durable power of attorney for financials, sometimes confused with an advanced healthcare directive, because sometimes people confusingly refer to advanced healthcare directives as durable powers of attorney for healthcare. This document is about financial assets. It gives someone the authority to make financial decisions and manage financial assets on your behalf. Additionally, like the healthcare directive, I recommend, and everybody else here would recommend, that once you're the age of 18, you really do need a durable power of attorney. If something happened, if you're 18 and something happens to you, no one's necessarily able to access your bank accounts and continue to pay your rent and pay your bills or manage your financial assets if something happens to you. Just being somebody's parent, once they hit the age of 18, you won't have the ability to just automatically go in and do that for your kids. So we recommend as soon as you turn 18 that you do have a durable power of attorney for financial assets. Psychiatric healthcare directive. Like it sounds, it is a healthcare directive, but this is a very specialized one. There are certain mental health facilities and places that deal with psychiatric issues that require something more than a regular advanced healthcare directive. This is not something most people need, but if it is something you think you might need, definitely have a conversation with us and we can help you out with that. Conservatorship. This is the first dirty word that I'm going to cover, the other one being probate, which is the dirtiest, but this is probably the second dirtiest word. What is a conservatorship? Just show of hands, anybody know what a conservatorship is? If you are at all aware of it, you're either probably a professional like me, or some people became aware of it through the Britney Spears fiasco that happened a couple years ago. She was very rich, and rich pop star, a little bit mentally unhinged, and so her father got a conservatorship over to help manage all that money because he, I think, rightly thought she couldn't really be trusted to make her own decisions. Unfortunately, at least in my opinion, that conservatorship subsequently got removed in the aftermath of the documentary, which advocated free Britney, and the next thing I knew, I saw her on TikTok juggling knives in her underpants, and I figured that might not have been the wisest decision. But what a conservatorship is something you have to go to court for. You have to petition the court. It's going to cost at least a few $1,000s off the bat just to do that. If the court grants the conservatorship, it gives you the power to manage somebody's financial life and or healthcare decisions and certain other issues about where they live, depending on the kind of conservatorship that you're asking for. There's a lot of disadvantages of a conservatorship. The court is heavily involved at every stage, not only in approving the conservatorship, the court will appoint somebody to represent the conservatee, meaning you're going to have to pay not only for your attorney, but another attorney that's going to represent the person you're getting a conservatorship over. That attorney is going to be scrutinizing everything you do. You're going to be likely having to file an accounting regularly that the court is going to comb over and require to be absolutely flawless. And it can create all sorts of issues. Anytime you want to do anything with any court, you're basically going to have to petition the court and get approval for. And I can say from experience that it also creates an added level of difficulty if you have to interact with our other dirty word, which is probate, because sometimes conservatorships transition into probate after the conservatee dies. And if you have any unresolved issues, any issues with accounting, any of those things, it can take a long time to resolve in the conservatorship, and those assets held in the conservatorship will not be released into the probate realm until you wrap them up in the conservatorship. So as long as probate takes, if you get stuck in a conservatorship, it can take even longer just to get to probate. So why do I bring this up? Because those other documents, the Advanced Healthcare Directive and the durable power of attorney for financial give you the ability to avoid a conservatorship. They give you the sort of management and control powers over somebody that a person would need if they're incapacitated that allows you to avoid a conservatorship. Wills. Obviously, the purpose of a will is to tell somebody what you want to happen to your stuff after you die, and it also is there to appoint somebody to make sure those wishes are carried out. Again, who needs a will? Everyone needs at least some type of will, but in general, when we're referring to, say, a standalone will, a will without a trust, I would advise everyone to have a will, especially I'm going to skip all the way to that third one on there. Most important, people who have minor children, even if, say if you have, how many of us have grandkids here? Okay, so if your grandkids are like me, they don't own a home yet because it's a little rough in Southern California to own a home. But if they're like me, they may also have a few rugrats running around. I'm currently cramming 3 into a 2-bedroom apartment, which is a lot of fun. But I need, and your grandkids, if they're in my type of situation, absolutely, even if you don't own a home, and even if your assets are less than the current probate threshold, which is $184,500, they will need a will for the purpose, or for the reason that it includes a nomination of guardian. If they want any say, if both parents were to pass away at the same time, or both parents were within a certain reasonable amount of time of each other, if they want any say in who raises those kids after them, they need to nominate a guardian. Otherwise, it's essentially up for grabs with the family. Someone will just have to file a petition with the court for guardian, and they're not going to get any say in it. So if you have minor children, if your grandkids, obviously in this case have minor children, they absolutely need to have a will so that they are able to nominate a guardian ahead of time. Different types of will. The basic one is a standalone will. That is just something that you need even if you don't have a trust. The kind of will hopefully most of you have is called a pour-over will, which we'll go over later. That is a will designed to work in conjunction with a trust. And there's also, how many of you ever heard the term holographic will? Anybody? Yeah. It can be either type of will. It's not really about the content. A holographic will basically just means it's written out in your own hand. You didn't type it up, you wrote it out yourself. That's all a holographic will is. Probate. This is the dirtiest of dirty words for us, as I mentioned. We really don't like probate. The purpose of probate is to basically settle all accounts. If anybody owes you any money when you die, that needs to be taken care of through probate. If you owe anybody else any money when you die, that needs to be taken care of through probate. And if there are any other sorts of legal claims, either on your behalf or against you when you die, all those things need to be resolved in probate. The other thing that needs to happen is your assets need to be transferred. If they're in your name and you die without doing any estate planning, we need to make sure that those assets go from you to whoever the court determines, or I should say California law determines, is the next person they're supposed to go to. We always like to say that even if you think you don't have a will, you do have a will because the state has written a will for you. If you look at the probate code, it has very detailed rules about what happens to your stuff when you die if you don't plan to the contrary. So if you're okay with that, that's one thing, but there's a lot of situations where the default rules are not okay. I, in my litigation career, had a case where a fellow wanted to leave everything to the grandkids that he had helped raise because CPS took all his grandkids away from his 2 daughters, which I affectionately refer to as the crackhead twins. Not an exaggeration, they were both lifetime crack users and gang members. Unfortunately, when he died, because of a lack of proper planning, everything went to those 2 daughters instead of the grandkids that he had raised his whole life. So the state has a will ready for you. You may not like it, so it's probably a good idea to do your own planning. So, as I said, it's a legal process that follows state rules. Control is not with you, it is absolutely with the court. You need all kinds of approval to do most things, and that requires lots and lots of time, energy, and attorney's fees, which in this case usually amount to about 5% to 7% of the gross estate. The attorney's fees in a probate are set. They're not you're not able to charge hourly. They're set as a percentage of the overall value of the estate, but there's a caveat. There's something called extraordinary fees, which means if I, as an attorney, do anything remotely out of the ordinary, I get to tell the court that those are extraordinary fees, and I get to tack hourly fees on top of what the state's already going to give me as a percentage of your estate. And believe you me, attorneys, any sort of thing remotely out of the ordinary, you might not think it's extraordinary, but anything remotely out of the ordinary, we're tacking up those extraordinary fees. And like I said, it's very lengthy. If you got out of, it's saying 18 to 24 months, if you get out of a probate in Southern California in 18 months, hats off to you, everything went perfect. 2 years is probably a lot more reasonable. And every firm that does probate administration, or at least most, not necessarily ours, but most firms I know, a dirty secret is they'll usually have at least some probates that have been languishing for 3 years, sometimes 5 years, maybe even longer when there's real problems. So, as I said, it's something that we absolutely want to avoid. This is just showing you a little bit of a breakdown as to where some of those fees come from. Median home value in Orange County, $1.2 million. Again, that's why I'm living in a 2-bedroom apartment. But you can see 25,000 based on that median home value. You're going to be looking at minimum 25,000 in attorney's fees, 25,000 for the administrator of the estate. You're going to be kicking at least $1,000 to the probate referee, which is somebody that appraises your property that's appointed by the court that you have to pay. Filing fees, publication fees. This is a fun, antiquated thing. You may not know this, but you actually have to publish notice in a newspaper of record whenever you are going to go to the initial probate hearing. You might think, wow, that sounds silly, but it is an actual thing. You actually have to find their newspapers that appear to solely exist basically for this purpose. And you gotta pay them a fee, and it has to be on the approved list, or the court will make you do everything over again. So, good news, hopefully you're all already aware of this. These proceedings are optional. Probate is optional and it can be avoided. As I mentioned, a will is not going to keep you out of probate, but there are certain kinds of will substitutes that can be distributed outside of probate. Life insurance is one of those. There are certain kinds of beneficiary designated accounts like 401ks and IRAs. So long as the accounts are beneficiary designated, it will be able to follow those beneficiary designations outside of probate. But our recommendation usually is that you use a trust, because there are things, for instance, an issue you can run into if you just rely on beneficiary designations. If the people you designated as beneficiaries are not around when you die, then your asset can still get wrapped up in probate. So if you've got life insurance and you designate, one person, maybe a backup person, if neither one of them are around when you die, it'll still get tied up in probate. So the safest thing we would obviously recommend is a living trust. Essentially, it's a contract between you and yourself, so long as you're appointing yourself as trustee. You essentially say, self, do I trust me to manage all my financial assets? And you say, yeah, self, I do trust myself. So you're essentially appointing yourself as the settlor. You're appointing yourself as the trustee to manage and invest all your financial assets. And within that trust, you set all sorts of rules about how you want the assets managed and what you want to have happen to them upon your incapacity and then upon your death. And obviously, a beneficiary is someone that the trust assets are to be used to benefit. You will be the likely only beneficiary during your lifetime, and then obviously after you pass, you'll designate beneficiaries to get your stuff after you pass. As I mentioned, benefits, it avoids probate. That is the number one reason people do trusts. It protects your privacy, something you may not know. Everything that gets filed in probate court is a matter of public record. There's not a whole lot you need to do to be able to access that information. I, as an attorney, can pull all sorts of documents off of a docket for any probate case, so I can find if there's any sort of personal information divulged about your assets, including if you have messy familial relations and people are fighting about stuff, I get to find all about that, and that is a matter of public record. So that's another reason to try to have your estate dealt with outside of the court. Doing a trust also allows for various kinds of tax planning, especially if you have a larger than average estate. one thing that people need to realize, it only protects what it owns. So a trust sets all the rules for what happens to your assets, but those assets have to be within that trust in order for those rules to apply. That's why it's very important, for instance, to make sure that your home is titled in the name of your trust. There are instances where, if you say refinance, where they might tell you to transfer title of your house outside of your trust. It's very important if that happens that you transfer title back into the trust, because a trust only protects what's within its confines. And as I mentioned, it avoids all those nasty court-supervised probates and conservatorship issues. Professional fiduciaries. If for any reason you have a need to, if for any reason you're worried about your kids directly handling the money, there's certain things you can do. You can bifurcate essentially the authority and the roles by appointing a directed trustee to take care of certain financial and other administrative matters so that your child doesn't have to do it. You can also appoint just either as a co-trustee or as the trustee itself a professional fiduciary, which we do have relationships with, which one of them is David's father, if you've met David, and he's a very good professional fiduciary. The pour-over will that I did touch on, you should, if you have an estate plan with us, you will have a pour-over will. It's called a pour-over will. The idea is that it'll collect any assets mistakenly left out of the trust and pour them back over into your trust when you die. So it's not the first option, but it's sort of a backup option we always put in place. It's a contingency plan. Unfortunately, a pour-over will have to go through probate, so that's why it's not the first option. Letters of instruction we can go into further if you want to have a conversation about this. We have various kinds of templates. Letters of instruction can allow you to leave certain kinds of specific instructions, including where certain assets are located, what you want. You can provide a list of people you want notified upon your death and how to get a hold of them. And you can provide all sorts of other specialized wishes and instructions with that. Digital assets, if you have any questions about these, we can help give you some advice about this. There's certain things you can do with your digital assets, such as appointing a legacy contact in Apple to make sure that someone's able to that your kids are able to access everything after you pass away. But we have a lot of advice and things that we can tell you about these sorts of things if you want to make an appointment with us. With that, I will get ready to turn things over to Larry. Larry's going to talk about life planning for every stage, and he has done more life stages than me, so he's a great person to do that.
Well, good morning. Let me correct Mark in one area. He says that probate and conservatorships are dirty words. They are to you, but they're not to us, because we get paid. It's a good part of our practice. So we don't want you to go through probate. We don't want you to have a conservatorship. That's why we're here. That's why you're here. But we make money on it. So if you run into an issue where someone is in that predicament, where they have to go through probate because something was not placed in a trust or the planning was not properly established, or if they end up in a conservatorship because they didn't do the powers of attorney, we're here to help. That sounds obvious, but a lot of you think all we do are trusts. And we do it all. We can help you there. One other thing. Let's see if I can go backwards. We failed to mention, if you look at the bottom of the page, there's a QR code. You'll see them throughout the slides. That QR code leads you to a video that does a far more extensive discussion of what we're talking about. So if in fact this feels like you're getting fed by a fire hose, this is a way to go back, take it slow. And you can actually see what you can do and what the topic is intended to cover. Let's see if I can go forward here. Now, key thing to remember with life planning, has anything changed in your life? We just had, the last 9 months, we've had 2 new grandchildren. Amazing. How many of you know that grandchildren are amazing? Unbelievable. So, didn't believe it before, but now I can tell you for sure, if you didn't know it, have more grandkids. Have your children grown up now to the point where you're ready to let them be in charge? Or have they grown up to a level where you're not ready to let them be in charge? Do you need to modify your distribution of the beneficiaries? Is anybody moving? How many of you know a lot of you have been moving out of state? You probably know people who have. If you're moving, talk to us, because oftentimes we may need to add tax language to your trust because of the state you're moving to. One good thing about California that James will tell you is we do not have an estate tax. So if you die here and you have $100 million, the state of California is not going to take a piece of it. But if you move to New York, you move to Washington, you move to Oregon, they're going to take a piece of it. We can reduce what they take by adding the proper language to help maximize the estate tax exemption in that state. So let us know if you're moving so we can add that language. Mark already mentioned this, but this is critical, so I'm going to restate it. Make sure that everything you have is in your trust. Your checking account, your savings account, your brokerage accounts. Make sure they're all titled in your name as trustee under your trust. That's the way you know it's in the trust. The other way, a secondary protective way of doing that is by keeping your listing of assets up to date. So many of you remember on your trust there was a Schedule A, B, C, and D, or A and B. Keep Schedule A up to date. If you'll do that, and it turns out you had an asset that was not in the trust that you thought was in the trust, you had a home, you borrowed money against it, and you thought they put it back, but they didn't. If that's on the schedule of assets, we won't have to probate it. We may still have to go to court, but it's a fraction of the cost if you'll keep that Schedule A up to date. The other part about that Schedule A, or the schedules in general, is it lets the trustee know what you have. So the trustee doesn't have to hunt all over the country to find your assets. Makes their life easier. And then make sure everything's current. How many of you know there's a difference between men and women? And what's the difference? If we men lose our wife, are we likely to stay single? Come on, you can speak up. We're not. If you women lose a husband, are you likely to stay single?
Yes.
I hope that's not an indictment of us men. Probably is, but the truth is you women don't need us, but we men need you. At least that seems to be the case. Obviously it doesn't apply to everybody, but what's the significance? If you're concerned about your monies that you've spent 40, 50, 60 years accumulating in the course of a marriage, and you want to make sure that it goes to your kids, what do you need to do? You need to structure some type of protection so that it stays in the family. So if there is a remarriage, you don't have to worry about the inheritance, the monies that you accumulated going to the bimbo. Proper, improper term. I'll call her Barbie. Going to Barbie instead of to your children. How do you do it? You can do it by utilizing the tax law. We can add other language in the trust where you agree to make restrictions in the event of a first death. That if there is a remarriage requiring the surviving spouse to have the new spouse sign an agreement giving up any rights. That tax planning you see up here is called AB planning. AB planning applies to what? Estate taxes. Are we using it for estate tax purposes with what I just described? No. We're utilizing it to make sure that at least part of the estate doesn't go to a new spouse, and thereby bypassing the children of your marriage. Do we have any issues with your kids? Same scenario. Do you know who your children are married to? Some of you, yes. Are they in-laws or outlaws? Let's assume they're in-laws. Same scenario, though. If your children survive you and they receive the inheritance money, but they don't survive their spouse, or their spouse fails to survive them, what now is a possibility? That inheritance money that you intended to go to your grandchildren can now end up in the hands of a family you have no connection to. Good news is you have the ability with proper planning, and many of you in this room already have it. It's called generation skipping planning, where you can build in protection so that the creditors of your children can't get it. so that if there's a lawsuit against them, they can't take your inheritance money to satisfy the judgment. Mentioned divorcing spouse, but let me go to the surviving spouse. Your child survives you but doesn't survive their spouse, the surviving spouse becomes a creditor in our definition here. The monies don't go to that surviving spouse. It can be used to protect the surviving spouse, your in-law, but ultimately it's going to go to the kids, your grandchildren. So just know that that's a possibility. But if you have a child who does have creditor issues and you still want to protect them, generation skipping planning does a great job of providing that protection. Dad tells a story of a client who had a son who had major IRS issues, had to leave the country. The generation skipping planning allowed him to come back after we negotiated with the IRS and gave them pennies on the dollar to satisfy the judgment of the monies that were owed to the IRS by this child. It happened because we had this planning in place. Basically, we told the IRS you can have 2% of something or 100% of nothing. And they took the lower percentage. Anyway, just so you know, this is available. If you have someone who needs special planning because of disability, you need to make sure or confirm whether or not in your planning you need to provide provisions for that person. Because what happens if you give somebody resources and they're on a government benefit program? What potentially can happen? They'll lose the benefits that you didn't want them to lose. On the other hand, many of you have enough resources, you say, I don't care about those benefits. There's enough money in my own estate to cover their needs. But you have to make sure that you don't cost them something. Because once you lose the benefits, how hard is it to get them? Pretty tough. So just be aware of that. If you have someone in your family, a beneficiary who has special needs, talk to us about whether you need to do special needs planning. And again, there's a QR code that goes into more detail where one of us covers those provisions. More detailed planning. Oftentimes you can use life insurance to pass on a business to a family member. Where you have one child who's in the business, you have 5 children. How do you equal it out? You can utilize life insurance for that purpose. If you have a huge or a large 401k or an IRA, what's large? I say over $3 million or $2 million. You can consider setting up a standalone retirement trust that becomes like a pension plan for the people who are receiving it. Do you have anybody in your family who is suffering from chemical dependency? Many of you who have recently done planning have seen that I build it in automatically. So if you have someone in your family who has an addiction or is controlled by alcohol or drugs, the trust says don't distribute to them. Hang on to it for their benefit. Pay for the things you would want to pay for. Inpatient, outpatient treatment. Meet their needs, but don't distribute to them. And once they show themselves to be clean for a period of time of your choosing, then maybe distribute. Or maybe not. But the point is you have the option. Really, there's more that Victoria and Kathleen are going to cover, or Catherine are going to cover a little later. But do you need to put into your trust what I was describing, the remarriage protection between both of you? The remarriage protection for your kids, or any other special things that apply to your family that you're aware of. With that said, I'm going to hand the session over to Victoria. You're going to find her to be amazing. I didn't mean to put pressure on her, but she is amazing.
All right, thank you. So we're going to get into legal changes. So who likes taxes? I didn't think anybody. All right, so one of the biggest things is taxes applied to us in a variety of ways, whether we like it or not. The other reality is taxes do not just hit us if we're in the uber wealthy or in the bottom percentages. It truly is applicable to every single person. With proper planning, though, there are a number of the taxes where we can either eliminate unnecessary consequences or at least reduce those unnecessary consequences. So that's the first part that I'm going to address when it comes to your planning itself. Now, this section is a very heavy section that we cover really quickly. So what I encourage again is take advantage of the consultations you get as a result of being here. Come in and ask further questions if any of these trigger, yeah, that might be applicable to me, or I want more information. The first one is Proposition 19. So if you've been to our seminars in the last couple of years, you've probably heard about this, but this is still a proposition that a lot of people are not aware of when it passed, what the consequences were in regards to your property and property taxes when it transfers down. It used to be that there were pretty flexible and beneficial property tax transfer rules when a beneficiary inherited a property out of your estate. Essentially, at this point, when someone inherits a property, no property gets a step up in basis for property taxes. What that means is when someone inherits, if they decide to keep that property, it's getting reassessed, with one limited exception. There is still a limited parent-child exclusion exception, but again, it's very restrictive. What the restriction is the only property that even qualifies to keep your property tax rate is your primary residence, but only so long as a child inherits it and keeps it and claims it as their primary residence. If they keep it and turn it into a rental, it loses your property tax basis and will be reassessed. So it is extremely restrictive. But you also have to properly plan in order to help ensure that even that exclusion can be captured. And that is by using what is called right of first refusal language. So let's use an example where you have 3 children. If in your trust you say all 3 of my kids are going to inherit my residence, we go through a trust administration, a deed is prepared, all 3 kids are named on that deed. And one of the kids goes, you know, I actually would really like to own and live in it, can I buy you guys out? The other 2 say, yep, not a problem, we'll take the cash. So now that child is buying out their siblings. That is not an exclusion that will be applicable because that is now a child-to-child transfer. 2/3 of that property get reassessed. So they only get their 1/3 that they got from the parent. If, though, you build into your estate plan that before that deed is done, that child who you think is the most likely would want it, you can give them the option to essentially pre-buy out the other 2 before those distributions are made. If they choose not to, they can't. You can have child 2 have that option. Child 2 says, no, I can't. Child 3 says no. Then it's up to them what to do. But you've reserved the option for them to do so. So this is something, again, especially where you have more than one child and you're concerned about this, if you think this is something that they may want to do, come in and talk to us. We're absolutely happy to do so. The one other way you can do it is by using an LLC, but this is extremely restrictive. It has to be that the LLC purchased the property with cash that the LLC had. So what that means is if you were going to buy a new property and you funded your LLC with cash, and you then bought this new property directly with the LLC, now when you die, and Catherine would be the one to talk to you about specific LLC rules, but now when you die, the LLC would transfer rather than the title on the specific property. But again, you can't retroactively do that. This is not an application for a property you already own. So if you are planning to purchase property, come and talk to us first. In most circumstances, very bluntly, it is cheaper to ask the question first rather than ask us after and potentially us have to clean something up. We're happy to talk to you and let you know this is something that will benefit you, or no, it really won't. The next legal change that's occurred is actually not about a tax, but this has to do with Medi-Cal. So really quickly, living in California, we are concerned about Medicare and Medi-Cal. We do not fall under Medicaid. So if you hear Medicaid, just essentially put that out of your head as far as California benefits. Medicare is dealing with, you've hit 65, you need health insurance. That's a very different program. That's one that we're not going to talk about today. But Medi-Cal is a needs-based program. This is a program that is looking at what your income is and do you physically need the care. I want to really emphasize the income change. Medi-Cal used to qualify you based on your asset level. At one point, the level was as low as $2,000. Then it went up to $130,000. Then last year, they got rid of it altogether. Now when it looks at can you qualify for Medi-Cal, again, you still have to physically need it, but now they will look at what your monthly income is. That is a very different analysis. If you had one of our old asset Medi-Cal trusts, I encourage you to come talk to us to ensure that either that trust still protects or does it need to be updated at all. But we also have what is called an income protection trust. If you are in a situation where you are going to need advanced care, whether that be in-home or even skilled nursing, and you are concerned about, I don't know if I can afford this, I don't know if I can afford to take care of my loved one who needs this, please come and talk to us. The rule change has opened the door in a lot of ways to people who could not have qualified prior, but we also have planning that can be done to protect certain sources of income from being used against you so that you can still retain benefits and not have to deplete everything you earn every month. So again, if this is a question or a concern, come and talk to us. This is a fundamental change, but the great news is we do still have those planning options. Back to taxes. So now I'm going to talk about the SECURE Act. So the SECURE Act involves not only an estate planning team, it also very much needs to encompass a financial advising team, which you'll hear from Lifestyle Financial a little bit later this morning. The SECURE Act changed, again, inheritance when it comes to retirement accounts, so your 401ks and your IRAs. The rules, again, shifted pretty fundamentally, not only when it comes to the financial advising side of how long you can contribute, when you can contribute to these plans, what you can contribute, but again, it also affected inheriting these plans. So now the rule is, when someone other than these exception groups inherit your IRA or 401k, they only have 10 years to withdraw the entire sum that you left to that person. So instead of your child inheriting and being able to just do required monthly minimum distributions, they now have to do that and withdraw the entirety within 10 years. Now you can imagine from a tax standpoint, that's going to have higher tax implications. There is nothing we can do to avoid that piece other than talking to your advisor now and figuring out, is your retirement structure still the applicable one? But as far as why this applies to your estate plan, Larry talked a little bit about those protective trusts for kids. So I want to very quickly recap to make sure it all ties together. If in your trust you say, when my child inherits, their inheritance will go into a protective lifetime trust, again, protecting from the divorce and those outside creditors, a lot of people want that inheritance protection to include their retirement accounts. But there's one issue with that. If you have these protective trusts and on your retirement accounts, you have your final beneficiary being your trust, and you have language in your trust that complies with the old rules, it can trigger when you die a one-time withdrawal or distribution rather than the person getting that 10 years. That's an obviously much higher tax concern at that point. With proper planning, and Kopenberger has this, you can have the updated language that would still allow the beneficiaries to have that 10-year period and allow those funds to be protected from those outside creditors. So if you have protective trusts and you have not seen us in the last few years, please come and talk to us. Or if you are concerned, you don't know whether or not you have the protective trust or whether or not you need that language, come and talk to us. Because this is a fundamental update to your legal language that needs to be made to ensure those extra taxes do not apply to you or to your beneficiaries. All right. Another tax. This one I actually, as weird as it sounds, I like this tax. This has to do with gift taxes. So this is probably one of the most misunderstood topics because a lot of people don't know about what is called a lifetime exemption when it comes to gifting. So a few things. One is each year the annual gift tax exclusion goes up about $1,000. So this year, each person in this room could gift to another individual $19,000 and never have to tell the IRS that you've done so. So that's great. You could be extremely altruistic, gift, and as long as to that one individual it doesn't go over 19, government doesn't need to know. But what if you're feeling extra generous? You're gonna pay for a new car for your grandchild, and in today's world, new cars can be $30,000 to $100,000 just for your basic model. Obviously, that's a little bit more than $19,000. Now, you do need to tell the IRS what you gifted in abundance of that $19,000. But they will take that extra and deduct it from your lifetime exemption, which right now is just shy of $14 million. So unless in your lifetime, as of this year, you gifted more than $14 million, yes, you had to tell the IRS, but they deduct it out of that pool. You don't actually get hit with a tax. So this is, again, one that I actually like because it allows people to be more generous without having any consequences. Again, any questions on that, come and talk to us. There's a theme here. Come and talk to us. For married couples, again, Larry covered those A-B trusts, but in a lot of cases, people don't have the A-B trust that automatically doubles your estate tax exemption. In a lot of our cases, people have trusts that went solely to the survivor. The estate goes solely to the survivor. But when a spouse passes away, your estate gets valued as of that date of death. When you work with the administration team, one of the questions they ask is for statements, for appraisals, for things for that specific date. If, let's say, I'm going to use round numbers. So exemption right now, I'm going to use the round number of 14 million. Let's say you passed away and your estate was 10 million. Well, the estate did not hit the entire exemption limit at that point. The surviving spouse has the ability to elect what is called portability. Essentially use the unused portion for that decedent for their estate for a future time when they pass away. That way, if the exemption drops, your estate goes up, you have this extra that you've added to your estate to hopefully eliminate or again reduce those estate taxes that are extremely hefty and we very much want to avoid. But it is something you have to elect. Now, you have a period of time in which to do it, but we always encourage at any period where you are ready to come and talk to our administration team. I say ready because grief is different for every person. This is one of the things that they can bring up and ensure gets elected if it is going to assist or help your estate. All right, I said that was a lot of taxes in a quick amount of time. Any questions on that, we will be around at the break and are happy to set up those consultations. I am now going to hand it over to our business and tax attorney, Catherine, who's going to go into more of the business and tax side.
Thank you. Thank you. Sorry, my iPad up here taking up a bit of space. So, to continue, don't worry, David, I have this. Let me go ahead and get started because this next section we're also going to move past pretty quickly. It's not necessarily applicable to everyone here, but just as Victoria was mentioning, this section, it's dense, and if it applies to you, come talk to us. Come set up a consultation, come ask us questions, we're here to help you. So most of this section is going to be applicable to small businesses. So I'd kind of like to get a sense of who's in the audience today. Anyone small business owners, please raise your hand. Got a little sense, a little high. Okay, so several, but not many here today. Anyone with rental properties? Okay, great. Even more hands, which is interesting. We're going to talk more about that. And for the few that have businesses, employees, do you hire employees? Do you have staff that, okay, well, thank you. So we're gonna move past some of these sections extra fast because there's only a few here that it will actually apply to, but particularly with the first section that we're gonna talk about for small businesses, landlord-tenant laws. Tenant laws get updated in California every year to some extent, right? This is governed by state law, and every year we seem to have some small changes to tenant laws. And of course, in California fashion, they're usually more tenant or pro-tenant. There's more protections for tenants and fewer protections or more obligations for landlords. So there are a couple of updates. I will leave these slides with you to review. I'm going to go over a couple of them. This is not an exhaustive list of all of the changes, but these are the most applicable changes. So first, let's look at just a couple of legal changes for residential tenants. So any, as opposed to commercial tenants, residential tenants. There are additional obligations for security deposits for small landlords. Small landlords are individual people or LLCs with only a certain number of units on a property, or only 2 properties that you rent. So we're talking about maybe you have 1 home that you rent out, maybe you have 2 homes that you rent out, or maybe you have a duplex that you rent out both of the units on. That's where this applies to, this entire slide. So there are limitations on security deposits now. They can only be up to 1 month, so for everyone, 1 month maximum. For the small tenants, like I was just mentioning, 2 month maximum for a security deposit amount that you can request or enforce. And as far as security deposit claims, there's a new obligation. And I also want to plug right now, so we have Elaine, she's been mentioned several times, she's part of our litigation, but she's also done a couple of webinars on this that are available online. There's several QR codes in your packet, and at the end, there's a whole page of QR codes. Elaine did a couple of webinars about September or fall of just this past year that covered these updates more extensively. So I strongly encourage you to look at these two if the tenant law changes apply to you. But this one was interesting, the second bullet point. So now for a security deposit claim, you have to have before and after photos. This is before and after tenancy, but also before and after work projects. So if you're updating appliances in the unit, but your tenant is currently living in it, before and after photos for those updates or any work as well. So make sure you're now taking photos before your tenants occupy the property, before their tenancy starts, and then also after as well, if you want to make a claim on that security deposit. There's a couple of smaller obligations about restrictions on charging additional fees. For example, if you pay by check, you used to be able to charge an additional fee for your tenants to pay by check. You cannot do that anymore in the state of California. And then for commercial tenants, this is more just applicable to small businesses. So I'll probably leave this. I'll leave this with you to look over. But similarly, more restrictive on landlords and more protections for tenants. The next section. So for all those business owners that went to any of our seminars last year, we covered this. We covered the Corporate Transparency Act. Interestingly enough, for probably everyone who this might have applied to, it no longer applies to. So if you have a pen handy and you're looking at this slide, you might want to just cross off this slide and the next slide. About a month and a half ago, the FinCEN, which is the governing body for this act, it's a federal agency, and it's a federal law. They changed this rule to only apply to non-US citizens and non-US businesses. So as long as you're a US citizen and a US founded business, you were formed in one of the states in the United States, this no longer is a reporting requirement for you. So, yeah, I think let's all give a round of applause. So cross those off, and I'm gonna skip. It's those 2 slides. Now the next 2 slides, I'm also just going to leave them with you. There are, similar to tenant laws in the state of California, there's a lot of updates each year on employment laws as well. If you have employees, or maybe if you are an employee and you want to know your rights, we can also help you with that at Coke and Barter, and Elaine can help on the litigation side if you're in any hot water with it. But these next 2 slides should just be a reference to you. There are new employee rights. If you have any questions or want to understand your rights more, please feel free. We are here to help. We set up a consult with us if you have any questions. And perhaps we'll cover some of this material more in future webinars. And then the last slide that I'm here to discuss with you before we move on to the next section is actually one that was in our previous year's presentation, because this took effect last year. There is an updated rule for your insurance coverage on your trust accounts. So the rule has become simplified. It's the same for revocable and irrevocable trusts. It's essentially that your coverage is $250,000 per unique beneficiary per trust owner. So keep in mind that if you and your spouse have a trust, that number is doubled. And that ends up being a full coverage up to 5 beneficiaries. So they've also capped the beneficiary coverage, which means that $1.25 million is your total coverage for up to 5 beneficiaries. But the cap exists regardless of the number of beneficiaries. That number is doubled, so it's 2.5 if it's a spousal trust. I think I'll go ahead and pass it over now, back to Victoria.
I'm back, but only for an introduction. So the next group that you're going to hear from is Lifestyle Financial. So at the very beginning, Lloyd introduced his wife, Laura. So she founded Lifestyle Financial about, 30 years ago now? So they have been around to assist families and ensure that whatever your goals are, whatever your family goals look like, your legacy goals look like, those can be accomplished. When Laura was starting the transition, she turned it over to their grandson, Charles, or Chaz as you may know him, and he has continued that legacy on. One of the big things, though, is it is extremely important to work with a financial group that understands trusts. It is one of the most frustrating things on our end when we work with financial advisors who do not understand trusts, or frankly, think they're attorneys and think they know more than they really do. That is a dangerous combination, to have someone who is trying to act in a profession they're not actually trained in. Now, obviously, Laura had a direct access to a trust attorney, so that allowed this company to really be founded in a way that can help accomplish both goals and ensure that you really and your family really are protected start to finish. So one of the other things is congratulations to Chaz. He just finished his MBA in financial management. So that is a huge, huge thing for him. So he has continued the education, the firm has continued the education to ensure that whatever the new rules are, again, you're protected start to finish. So with that, I'm going to turn it on over.
Thank you. Well, good morning. I just want to tell you what a pleasure it is to be with you here today. I used to make a joke and I'd say there's no better way than spending a Saturday with you wonderful people, and there's nothing I'd rather be doing. But to be honest, I'm really happy to be here because I used to be sitting at my kitchen table for about 14 hours a day on Saturday and Sunday, and I'm really happy to be done with school. But I learned a lot of wonderful things, and so I think it's going to be really helpful. But again, welcome, and it's a pleasure to be here today. So I'm Charles, I'm with Lifestyle Financial. My grandmother started this firm about 30 years ago. I'm sure many of you have met my partner in crime, Zachary Raymond. He's the other advisor that works with us. He's a wonderful individual who couldn't be here today, but you got to talk with his lovely wife, Victoria. And so I'm just gonna jump in here, but Lifestyle Financial, we are a family helping families, and that's not just something we say. And so you already know who I am, and what we do is we help families, individuals, and small businesses work and plan their financial goals out by helping them with their investments, with their financial plans, and then also providing ongoing financial advice. So I'm going to start with a simple but very important question, and that's, what if you could safeguard your legacy to ensure a secure future for your loved ones tomorrow? I think legacy is why we're here. I think it's very clear that you care about your loved ones and protecting them and taking steps so that way you have a plan, because you've done the hard work of creating an estate plan. But there's also things to be done on the financial side. And so why does financial and estate planning matter so much? Why is it important? Well, it's important because you want to make sure that you're prepared to transition things to the next generation and your loved ones. It's not just about building wealth. Even the best, I use the word best, you're not supposed to do that. Even the hardest performing stock portfolios, investments, real estate assets, no matter what you have and how much wealth you built and how well that's performing, without a good plan, those assets can be left vulnerable. And you want to preserve that legacy and protect it and make sure that regardless of what's going on in the market with various market conditions, that you're protected. One of the biggest things that we notice is that you want to make sure that you don't have a missed opportunity. And so many clients or potential clients that we meet with, people don't frequently revisit their investments. And that's a mistake. You want to ensure that you're constantly revisiting and reviewing your investments to ensure that they are good investments for you today, tomorrow, and several years from now. Because as you grow through your financial journey, your goals change. The amount of risk you want to take changes. And I'm sure a few people have noticed, would you say the market changes once in a while? I'd say there's been a lot of changes in the last 90 days. And so that's where we come in. And we offer a balance between active management, good communication, and then just ensuring that there is balance. Because like many things in life, balance is important when it comes to financial planning. Value of creating that comprehensive plan. So, like I said, there's a lot of different things that are happening in the market right now. We've got interest rates that so far are stable, but I would say things are getting more and more expensive. We're seeing a little bit of inflation from time to time, right? But we're also looking at the next investment cycle, where that innovation is going to drive the market, where the future growth is going to be coming from. And again, dealing with the persistent geopolitical and economic uncertainty, because there's always going to be questions we have, and that's where, again, we come in and we help provide some of that guidance. And so going back to that legacy and ensuring that you're protecting your family. I hear advisors talk about financial literacy, and it's not just about, understanding, what a 401k is or what my retirement rules are, how much I have to take, but really how it fits inside your plan. And so what we've been doing at Lifestyle Financial is taking a much more holistic approach, looking how not only your financial plan factors in, how it integrates with your estate plan, but also your legacy, your goals, and what you want to do. I'm a pilot, so I always talk about the 40,000 foot view. But I like talking about the 40-year view. Because even though it's important to think about tomorrow and the next 5 to 10 years, as financial advisors, we're looking at the next 40. Because we care not only about you, but your children and your grandchildren. Because after all, it's about legacy. And so it's really important that, just like you have your estate plan and you're going to make changes to your estate plan, financial plan is no different. And so as your family grows, as your family changes, you want to ensure that you update that financial plan so it works together in harmony with the estate plan. And also, as things change, looking at things over the horizon, whether it's the market, whether it's a need for more income, as life changes, ensuring that that plan is updated to reflect those changes. So, going back to this, I want you to think about this question. What's the financial legacy you'd like to leave behind? Maybe it's ensuring that your family and loved ones are taken care of, perhaps supporting grandchildren in college endeavors. Maybe there are some charitable organizations that you really care about. Regardless of your goals, my role and our role at Lifestyle Financial, if you choose to work with us, is we want to help support those goals and help you implement that legacy and that transition to ensure things transition as smooth as possible. So, as a thank you for coming to this seminar today, if you would like, everyone here is eligible to have a complimentary meeting with us. We can talk about whatever you want for 90 minutes, whether it's your existing investments, whether it's a financial plan, whether you just want to learn more about what we do and what our process is. But we are here to serve, and that's really a principle that my grandmother and grandfather really drove home with me in the very beginning when I started. And they said, son, if you're going to enter this business with us, there's just one thing you need to understand, and that's you're here to serve people, and as long as you understand that, you're going to do just fine. And so we are here to provide service, so if there's anything we can do, we're more than happy to help. But with that being said, thanks for coming, and I'm going to hand it over to my grandfather.
Thank you very much, Chad. Chad first started coming to these seminars when he was about 5 years old. They used to give him the sign that says, "Stop, boom, pop." Because I have a tendency to talk longer than I should. I'm going to ask Victoria to come and join Chris and I. I don't know how to approach this because we have so many people here today who are really guests who are just looking us over. And I'm about to talk about something that is really important to me to make sure that my existing clients have an opportunity to become part of Access before we change that total program. So if you're a guest here, we're not trying to sell you. We're trying to make sure that our existing clients who are not part of the Access program have an opportunity to decide whether it's something they want to join now or whether it's something that they want to leave the relationship as it is. Let me ask, how many of you here are Access members? Quite a few of you. At the risk of getting shouted down, I'm going to say that about 25 years ago, I created this program. It's one of the few things I've ever done that I've not ever knowingly received any criticism about. Now, that isn't to say somebody didn't criticize, but nobody ever told me, and most people are very happy with it. Here's the dilemma we face. As our firm has grown, originally we limited the number of Access members to 2,500 people because that's what we felt like we could keep our commitment to have the relationship with him that the Access program guarantees. Obviously, from the people you met today, we have expanded our staff significantly. We're in a position now where we're able to increase that number of people. But we're also expanding the firm into areas of the law that the original access program was never intended to be involved in. And so what we want to do is we want to tell you about what we're going to do to the existing access program. You don't have to do anything. This is just going to happen. How you can enhance that program by upstepping, and there's some significant economic benefits to upstepping it within this period of time that's available. And so again, without any further delay, I know we're starting to reach the point where everybody needs a break, but let me ask Chris and Victoria to tell you about the program, how it's going to change the basic access program, and how additional programs are going to be available to provide much further programs involving our service.
Thank you, Lloyd. Just by show of hands again, can I see how many access members there are? Get them high. There we go. How many of you have been access members for more than 5 years? How about 10? How about 15? Long time. All right, great. So the most important thing, like Lloyd said, is there's nothing that you need to do. The program is going to change regardless, and all you need to know is that if your hand was just raised because you've been an access member, you are an access member, is your benefits are increasing. We are not taking away any benefits, we are only adding to them, including the annual credit that you get. We're actually raising that up, all right? There's also going to be some additional benefits that are going to be added. You will automatically be moved into the new program. The new program is going to have 3 levels. There's going to be the foundation level, the heritage level, and the legacy level. The prices are going up for those, but you don't have to do anything. You get moved into the foundation tier automatically. If you choose to move into one of the other tiers, you'll be credited the price at today's price of what it would be to join. And that will go on forever. So let's say in 5 years you want to upgrade to the next level, you would be credited with whatever the base tier would cost at that time. So we really want to honor our access members. We're increasing the accessibility, the benefits, everything in that realm. So you don't have to do anything. You'll get new cards. We'll have some digital cards available for you as well that'll have your membership number and everything on it. In terms of the levels and other things, as you go up in levels, you start getting access to benefits in the other practice areas of the law. Right? So we have business, we have tax, we have litigation, we have administration. Those benefits currently don't extend to the access membership. Right? If you want to go in and you want to have an estate planning consultation, that's always been covered. If you have estate planning changes, that's always been covered. But if you wanted to go and start a LLC or have tax work done, you didn't have the same benefits. Now in those tiers, you will have access to all the different practice areas across the firm. Right? So that's a major change. The other major change, like Lloyd said, is we've always capped it at $2,500 because that's what the law firm could reasonably service and make sure that we were keeping the standards high. As you guys saw in the beginning of the slide, we've grown significantly since the access program was started. So we're increasing the cap to how many members we can have join. So what you need to know is pretty much that. We will send out a lot more information, starting with the existing access members and then the other clients as well, giving an opportunity to join. If you have any questions, I will be at the access table outside, and I can answer any questions one-on-one as well.
You might mention that we're offering the base access program today at a pretty significant discount for people who are already clients who are the seminar.
Correct. So the foundation tier is going to be launched at $4,800, which is $300 more than we've been selling the access program for a number of years. At the seminar, because you get grandfathered in, you can join for $3,800 today, and then you'd be grandfathered into that foundational tier. The other major benefit is if you do get grandfathered, you will never have to pay into any of the monthly costs. Each of those tiers are going to have a monthly cost associated with them as well. Existing access members will never have that. So if you get grandfathered into the program, there's no monthly fees for you ever, and it will stay just like it has for you, where you pay one time and then you never have to do it again. All right? Great. Perfect. I'm going to hand it over to Victoria. She's going to introduce Risher Mortuary.
Thank you. All right, so I'm going to jump backwards a tiny bit. So when we're talking about legacy planning, everything to do with it, one of the things that comes up, especially for kids who are starting to think about the end of their parents' lives, is what do I do if my parents have not pre-planned for what happens after they pass? That is one of the most stressful questions for the person who is going to be responsible for what literally happens to your body after you are gone. Having a mortuary set up is huge. It is one of the best gifts, as odd as it may sound, that you can leave to your family. To have it set up of, when I pass away, what is, again, literally going to happen with the body. My grandma had a mortuary contract before she passed. I was going to be the person in charge after she died. It was the easiest part of her passing, is I was able to call them up and say, my grandma has passed, here was the contract number. They took care of everything I needed to make sure she was honored and that things went off without a hitch. Risher is going to be out. We have our vendor area where Lifestyle will also be. It'll be to the doors on my right, your left. But I encourage you to talk to them. I encourage you to truly look into having that planning set up ahead of time. We are now moving into a 15-minute break. We'll come back, and we're coming back. Really quickly though, before we get to the next section, I want to make sure it's clear. For the Access program, that $3,800 is applicable today and for the next 30 days, but after that the price does go up. So you don't have to make an immediate game time decision, but you do only have that 30 days to take advantage of that price and waiving the monthly cost. All right, with that, I'm going to turn it.
We will do credit cards and we will work with them on payments.
And we will do credit cards and work with you on payments. All right, perfect. With that, I'm going to turn it over to Lloyd to introduce this next section and talk a little bit more about high net worth with Catherine.
Thank you, Victoria. The one area of the firm that I'm staying very actively involved in won't apply to very many people, but I want to say it because I've never in the past really talked about it, because I've always taken a position in our firm that everybody who came to us was God's child, and we were to do whatever we could do to help them regardless of how many zeros they had in their bank account. But at the same time that was true, I have planned some of the largest estates in the United States. If I were to stand up here and tell you the names of people I've done their estate plans for, you probably wouldn't believe it. But if you have an estate that exceeds $28 million, you don't have to go to another law firm to get assistance. We can provide you help in planning your estate so that your estate does not go to the government, but it goes to your family when the time comes that you go home. And so Catherine's going to be talking about some of the estate planning tools, but I wanted you to know that this is an area that I'm actively involved in. I intend to remain actively involved in it. And so if you fit in that category, you don't hesitate to contact us. I will be working with you personally. Catherine?
Thank you, Lloyd. So this next section, we call alternative and advanced plan. So like Lloyd just mentioned, we're going to cover some topics that are for high net worth clients. We're also just going to cover some alternative concepts that could be useful for a lot of other people. I want to draw back to when I asked the questions in the previous section. There were a lot of hands that went up for business owners, a good amount, and there were more hands that went up for landlords. Now, that may be that you didn't raise your hand when you were thinking about it from a business perspective, but typically, one of the most advantageous vehicles that we have available to landlords is the LLC, which is a business. So sometimes we don't think about it that way. Let me lay some foundational groundwork here, though, and say there's other webinars that we have on this. I've done a couple about different business structures, if you're not familiar. What I want to cover right now is a smaller subset of that. So LLCs are limited liability companies, and corporations, I just want to mention, also have this unique trait, but are really cumbersome, not so great for small businesses, not as beneficial because there's more reporting requirements, so I usually put them to the side. If you're looking at larger businesses, if you need VC funding, if you're for growth and scale, if you're an entrepreneur, a corporation may be what you're looking at, but for most small businesses and for landlords, an LLC is the vehicle that we want to hone in right now. Those two entity structures, those two business structures, have a unique trait of corporate veil, what we call in our legal jargon, corporate veil. This is a personal liability shield. This says that any creditors, any liabilities, debts, any lawsuits or anything that are encountered against your business, assets within this business, there's a shield between you personally and that business by the creation of either an LLC or a corporation. LLCs are really simple to manage. In the state of California, they do have an $800 franchise tax mandatory minimum annual each year. But other than that, not a ton of reporting requirements, not a ton of obligations, very flexible tax structure. For landlords, what are we looking at for liabilities? Any number of them, right? Slip and falls, say there could be any number of incidents, or there was Elaine has a great story about a septic tank that exploded on one of the properties, and the nightmare that ensued from that. What you look at when you're a landlord, and I do want to take a moment to also point to umbrella insurance or insurance policies and how that relates to an LLC structure. Because these are an and structure. We want both of them. The way that I look at the umbrella insurance or any insurance for landlords is that insurance covers your business assets. That protects what you put in the business. And when you're looking at an LLC for as a landlord, you're actually putting your property into the LLC. So you need insurance to protect your property. For personal liability, though, all of your assets that you maintain separate from that business, and any number of things, including maybe your other rental properties, you can segregate them with multiple LLCs. So that allows a fairly inexpensive and very protective and holistically protective option for you as an individual against any of those liabilities on your rental properties. Now, the LLC is not just for rental properties, so we're also looking at it for many small businesses. But I specifically want to address it in the rental property space because I know we had a lot of hands up for that. What we at Kopenbarger can help you with, though, extends far beyond that from a business perspective. So I take this moment to also just pin into your mind that we can help you with a lot of other business compliances, so business compliance obligations. So if you are a small business and maybe you have a brand that you want to protect, maybe you have, which is intellectual property, maybe you have copyright, maybe you're a writer and you want to protect all of your works. We can actually help you with that at Kopenbarger. We can also help you with some of your HR and employee, if you do have employees, any of those requirements too. So I just take this as a moment to mention some of the other tools that we have in-house that we can help you with that aren't really at the forefront of our clients' minds. beyond just your normal business compliance, making sure that you have your annual, if there are annual reports that are required, or any other reporting requirements for your businesses that are standard across. Now, just as Lloyd was mentioning, now I'll briefly kind of highlight for our high net worth clients, or clients that are looking at that gift and estate tax exemption, and they're pushing that boundary, and they'd like to have a tool to help make sure that they can minimize their taxable estate and control their legacy, as opposed to passing it over to the government to make whatever decisions they want. I do just want to say, let me jump to this slide real quick. So we have a lot of different vehicles being tools or methods to be able to minimize your taxable estate or achieve some other goal, but commonly it's to minimize your taxable estate. Some interesting characteristics with irrevocable trust. So the first half we're talking about revocable trust for the most part, right? Trust that you can control and manage while you're here today. With irrevocable trusts, because they are irrevocable, the IRS treats their assets differently, right? Because you don't have the same level of control over them, they get certain tax advantages. So a charitable remainder trust I want to highlight, or a spousal lifetime access trust, just a ton of acronyms, among others that aren't represented here, are potential options to minimize that taxable estate and achieve a goal. So for a charitable remainder trust, you could be you set up an irrevocable charitable remainder trust, you're receiving, or your family's receiving, the benefit of it for a certain period of time, and then the remainder, just as the name states, goes to a charity, gets gifted to a charity at the end of a certain time or at the end of your passing. Spousal lifetime access trust, follow the name, goes to the benefit of your spouse, and can minimize your taxable estate. And then the other one that I want to highlight is also a little bit unique, so a private foundation is something we can help you with. This is great for individuals that want to create a lasting family legacy that has a value that you want to instill on your children, your grandchildren. So you can set up a private foundation that has a specific goal that matches and aligns with what you're hoping to accomplish, what you believe, it holds your beliefs as well. And you can get your children and your grandchildren involved with the management of that while you're still here today. Make sure that they understand those core values that you want to instill in them. So, and while achieving some very tax advantaged benefits. So if these are things that you think you may want to do, especially if you're hitting that estate tax exemption, please come see us. We will discuss your options, and we can get the right structure set up and help you plan this. Now I'm just going to go back because another point that I want to present is also just before you act. Please keep in mind that gifting, so I just talked about gifting in for an irrevocable trust. Victoria talked about gifting earlier. Gifting may be something that you want to, if you have a highly appreciated asset, consider gifting the asset. So a lot of people may intuitively say, okay, I have to liquidate the asset so that it has, its X value, and then I'll gift the liquid asset. But gifting the asset itself may help you avoid that capital gains. So this is why that capital gains tax. So I want to state this just so that everyone here knows, come talk to us first before you take any of those steps. Because before you sell something, come discuss it with us so that we can help achieve the most tax advantaged method of transfer. But now I'm going to go ahead and turn it over to our whole, or a good part of our trust administration team. I'm going to turn it over to James Kosarev and Megan Wilson and Mark O'Brien.
Thank you. Thank you. Thank you, Kathy. All right, a whole bunch of us up here today. So, those of you who don't know, my name is James. I'm one of the attorneys in the office, and we've been administering trusts here for 30 years or so. I have been doing it almost 30 years. I know I don't look that old. I know, if Megan and I stand next to each other, we look the same age, but, no offense to you. But I will admit that when I first started, people were telling me that some of the same stuff they tell Megan, are you old enough to be an attorney? So I have empathy for her. Mark, he's always looked old. He was born looking this way. These are, Mark and Megan are both, I will say and admit to, they're both smarter than I am. So we've got a good crew. Mark's going to help me. Is there another mic there, or is it just number one? So okay. Well, we'll share. We may have to do like a duet. That's okay. So Mark and I are going to speak today. Megan's going to speak probably in a couple of other seminars later on this year. We're sharing the load now, so you don't have to continue to listen to my droning on and my stupid jokes and everything else as we go through this from now on. So again, I'd like to introduce, as part of our administration team, Mark O'Brien and Megan Wilson. All right, so administration is all about a process, right? It's what do I do? So somebody passes away, somebody becomes incapacitated, and we get a phone call, and it's like, what do I do? That's the question. What do I do? That everybody wants to know. And we want to know that too. Because we don't know what the whole situation is. This thing's in my way. We don't know what has to take place. We know some of it, right? Because we've been involved over the past couple of years. We've been involved in showing you some of the things that have to happen. If somebody becomes incapacitated or somebody passes away, it's a process, right? And so let's go through some of these slides, and some of them I'm going to ignore. Wait a minute. My age. When I started this, I didn't need glasses to look at these monitors and stuff. And then I needed glasses just to look at the monitors. Now I need glasses to look at the monitors and see the names on your breasts and chest. So now it's just a mess. Now my eyes are a mess. All right, so administration. So it's all about what do we do? I'm going to pass through some of these real quickly. This is your family. Believe it or not, that's your family. That's going to happen. And my dad died in January. My dad passed away in January, and now we're administering the estate. And my parents had 6 kids. I have 5 siblings. Well, if I don't count them all, maybe there's only 3 that I count. But I have 5 siblings. And so some of the stuff that happens is stuff like this. My brother and I were always going at each other when we were younger, right? And it's not, we've had, we fought sometimes, quite a few times. And I'm talking about fights. But most of the time we get along now, right? We like each other, sort of. And so when I was growing up, the thing I enjoyed the most, right, was making toast with my mom, right? So what's the most precious thing to me in my mom's house, right? At the end of her lifetime, and what do I want? Toaster, right? But what happens? My brother's older than I. And so when they're picking, right, when everybody's picking the personal property that everybody gets to take, what's he going to take? The toaster, right? Knowing that that's what I want. But that's what happens. That's what happens. There may not be any lawsuits, right? But if you have kids, any of you have kids? None? Okay, so I don't have to worry about it. Did any of you have parents?
None. Again, you're all clones. Okay, so from that perspective, right? It's like, okay, if you have children, or if you were a child or something. I mean, if you're an only child, you don't count, right? That doesn't count. I mean, unless you're arguing with yourself, you know, that's help we can't help you with. That's stuff we can. But suffice it to say, if you're arguing over stuff, right? If when you're a kid, you fight, and all those things happen, and it happens later on. You don't always agree. I mean, it may not be to the point, like I said, where there's a lawsuit, but there could cause some tension. Right? Tension will happen. And so this is the family. And what they're fighting over, if you haven't seen it, you know, there's a crown. There's a gold crown with a ruby in it. Or no, not a ruby, emerald. It's green. So it's got to be an emerald. So anyway, process. It's a process. So part of the process, there are, I would say, 4 main disciplines in the process. The first one, I think, is very intuitive. It's what the trustee does all the time, right? It's like, my dad had a residence. There was insurance on the residence. The residence gets sold. What do I have to make sure I do with the insurance? Cancel it, right? My dad had a car, right? And there was insurance on the car. If I get rid of the car, then what do I got to do with the insurance? Cancel it. My dad lived in the Royal Grande. I live in Orange County, right? He's in San Luis Obispo County. I'm in Oxford. What do I have to do with his mail? Forward it, right? I think some of it's intuitive. What we usually go through over the course of this time is the things that aren't so much intuitive. And the other 3 disciplines then being, right? What does the law require when somebody becomes incapacitated or passes away? What are the tax issues that need to be discussed? And then how do assets transfer? So last year, if you were here, you heard me babble on about, you know, the tax issues. And the year before, it was everything about the law. So this year, we're going to focus on how do assets transfer. So in a very quick review, because I can talk very quickly, as I've already probably figured out, we're going to go over some of the things that the law requires. Update land records. Send out notices. There's notices to beneficiaries. Updating the land records is really simple. It's not a trust issue. It's a real property issue. Right? And so it has nothing to do with the trust, has nothing to do with probate. Well, it could have things to do with probate. But it's really about, if there's an asset in the trust, my dad had his residence in the trust, and his name was on that as trustee, and he's now gone. I've got to update the land records, right? I got to put my name on it as a trustee, right? And then I have to notify, one of the notices is notifying the county assessor, right? County assessor wants to know what? Whether they can reassess the property, right? So we got to send out this notice. I have to send notices out to beneficiaries. You know, if Mark's a beneficiary, if he's one of my siblings, I have to send him a notice saying that Dad died, and he was at the funeral, right? He's a son, he was at the funeral. Yeah, well, yeah, hopefully. You know, but and some of them aren't. But suffice it to say, right, he's got to still get a notice, because that's what the law requires. Well, when my mom passed away, my dad was devastated, and so I helped him do a lot of the things that had to be done. I prepared 6 notices. Remember, my mother had 6 kids. I prepared 6 notices. I sent all 6 of them to my dad, and he sent me mine. Yeah, why? Because the law required it. The law required it. So we did it that way. And I'm just telling you, so some of this stuff sounds ridiculous and ludicrous, but it's like, yeah, but it's a process. You have to go through the process. You have to do those things. Lodge the will. Somewhere around 1850, a law was passed that says if anybody passing away with the will have to send it into the court for safekeeping. Not your trust, the will. Okay, so we do that. Right? Got to get a taxpayer identification number. Right? What happens to my Social Security number when I die? Goes away. It's no longer valid. So you got to get a substitute number for the estate, the trust, or whatever the case may be. Here's a bunch of codes. And this isn't all of them, right? I'm sure you have this in your material. But these codes essentially say that if I'm the trustee and you guys are all beneficiaries, I have to treat you a certain way. And guess what? It's not poorly. I'm not supposed to treat you poorly. I'm not supposed to keep secrets from you. Right? I'm supposed to be telling you everything. Right? And I have to do what's in your best interest, not in my best interest. That's what all of this is about. I have to report to you. I have to. There are things up there like an account, which is a financial record. It has to be done. Trustee says, I don't want to do it. I said, I don't care. The law requires it. You gotta do it. Now, and only the beneficiary. So you guys are all beneficiaries. I'm the trustee. My dad died. You're all in his trust. I read it. You'll get your notices soon. Right? But at the end, when I'm all done with everything, if I have a check, and I'm just handing you the check, and I say, here, this is your share. What are you thinking? My share of what? Right? Well, what did you start with? What bills did you pay? How much did you put in your pocket and, skim off the top? Right? Because nobody thinks good things about me if I'm not telling you anything, right? No, I have to tell you everything. I have to show you everything. That's my obligation, my requirement. These are things to do. So, co-trustees have to do everything together and agree to everything. Everybody know how I feel about co-trustees? Yeah, I hate them. Can't stand it. Right? You're going to be the bane of my existence if you have co-trustees on your trust. Okay? Even Mark. Why? Because it means I have more than one boss. How would you like to have more than one boss? How would you like to have more than one? Congress is a committee. Co-trustees is a committee. Co-trustees are about maybe a little bit more effective than Congress in the California legislature, but still. Right? I don't like them. Have too many bosses, too many things to do. So, but you're the boss, not me. But these are the things that have to happen. Anything else I want to go there before I go to the next slide? Anything you want to say? No. Not yet? None of this? All right, we'll move on. So that's kind of the overview. Now, here's some of the notifications. County assessor, beneficiaries, Department of Health Care Services, IRS, right? The IRS wants to know who's going to pay the taxes. Lodge the will, get a tax ID number, trustees' duties, income tax returns, right? On the tax part of it. So my dad died in January, right? And so I have to file what? A final return for him. January 1 to the date of his death. And then the trust, because it got a tax ID number, is now going to file for the rest of the time. Right? So there's tax ID numbers. Fiduciary returns, personal income tax returns. Estate taxes. I think you might have heard something a little bit about estate taxes earlier on. Right? So the credit's almost 14 million. Yeah, 13.9, almost 14 million. Right? But if anybody's got that kind of an estate, then you got to file. You got to prepare and file. Portability. If you're a surviving spouse, do you want to take the leftover from your spouse and move it onto your side of the balance sheet? Right? Portability is a big issue. And then income tax, basis. Everybody know what basis is? Right? It's kind of like, if you're any accountants or anything like that, this might be, nails on the chalkboard, but it's basically what did I pay for something? So if I paid $100 for something and sell it for $300, what happens? Tax-wise. Yeah, I have to pay tax on that $200, right? But if I buy something for $100 and I die and it's worth $300 and the family sells it for $300, no tax. So you got to track it, you got to mark it, you got to value things. Real property needs to be appraised. Stocks, mutual funds need to be valued as of the date of death. Gold, silver, let's see, anything else for that? Classic cars, anything, right? Things that tend to go up and down in value need to be valued, right? Otherwise, one thing that happens if you don't track this stuff, you're either paying too much tax or not enough. And I think both of those are bad. Because the IRS isn't going to tell you if you overpaid. I've never seen it. They tell you if you underpay, but I've never seen them tell me if I overpay. They just say, well, I'll just keep it for next year. Or, hey, this is what you think your tax is. So, and property tax, at this point in time in California, I don't think there's any exclusions. There's a very narrow one, but in most instances, part of that property or all of that property, your residence, and it only applies to your personal residence that you're living in, that is going to get reassessed unless a very narrow exception applies. So you know, and that's for all of those people. None of you did it, but that's for all those people who voted for that Proposition 19 a few years back. Ownership. I would say that, and Mark's gonna, you're gonna get a rest from my voice. Mark's gonna start talking here in a little bit. But I would say this is probably the most important part of your trust while you're alive, as far as making it operate properly and efficiently, and after your lifetime. Because this dictates whether some form of legal involvement from a court perspective will happen after your lifetime. So, everything about here.
Thank you, James. Kind of before I begin on this whole ownership aspect, as you can tell from what James has been talking about, the main thing is you have put a estate plan into place, but everything that we're doing and talking about is more of reality. All of the actions that you have to take, all of the things that you have to do are considerably different than when you sit down to design the plan. Right? It's a whole different ball game, and a lot of times the plan was perfect, but the execution is not. Right? You have a lot of grief, a lot of emotions, a lot of people putting pressure on you, and there's a lot of things that have to go on. So James and I, really what our role, what our department does, is kind of walk you through all of those actions, all of those items. Most importantly is what happens when the asset isn't in the trust? What happens when it's in your name? What happens when it's a joint account? What happens when it's a retirement account, right? All of these things have different actions. They require different things, different claims, different communication, different documents. So I'm going to kind of go one by one here, kind of give you like a line item, brief overview of what you have to do depending on the circumstance. So when you have sole ownership, right, I have a bank account. It's in my name, right? If I pass away, that is subject to probate. Now, you don't automatically go run to the court and file a probate. There are other things we can do, but normally speaking, that is the case. So it's very important, and I'm going to hit on this numerous times, and our estate planning attorneys previously did, when you create a trust, fund the trust, okay? If you have a house, put it in the name of the trust. If you have investment accounts, in the name of the trust. Everything that you pass away with outside is subject to probate, okay? For joint tenancy, with right of survivorship, a lot of times you'll have a joint account, or you'll take title to your house that says joint tenants. All that means is when one joint tenant passes away, it automatically transfers to the surviving joint tenant, okay? Now that sounds somewhat easy, right? It's an easier process than dealing with a trust or a probate administration, but there are tax implications, and then what happens if that second person passes away? We're right back at square one. We're having another probate, right? And the whole idea of this is to avoid probate, okay?
So there's one other joint type of account that people can have, and doesn't necessarily have to be an account, but it also could be a real property. Right? You could have bank account, investment accounts, you can have real property jointly as tenants in common.
Right, and then to kind of specify the difference between that, so I'll give you kind of a real life example. Right? You take title to your home. It says husband and wife as community property, right? Or it says husband and wife as joint tenants. Or it says husband and wife, nothing at the end of it. Right? The joint tenancy aspect we kind of covered. If one of you passes away, it automatically transfers to you. Right? We just update the land records. If it just says husband and wife, the law has a default, and that is tenants in common. If you own an investment property with somebody, and it just says your name and their name as 50%, there are rules in place. It doesn't say joint tenants on there, it just says this individual, right? It'll go to that person's heirs at law. right? Where that may have not been the agreement between you and your business partner. It may have not been the agreement between you and your spouse. Right? So it's very important that you're sitting down with an attorney and looking at how title has been taken to each asset. Community versus separate property. This is a community property state. So if any of you are married, right, the presumption is that your assets are community property. But a lot of times, people don't understand from the real life example of, okay, I have a bank account in my name. I was talking to one of our employees at our last seminar, and they didn't understand this because they thought that if I passed away with an account in my name, it's automatically separate property. Right? And the example I gave them was, okay, what if I open an account in my name and I start funneling my earnings from Kopenbarger into that account? And I pass away. It's just in my name. Is that separate property? Right? And the answer would be no, because my earnings in California are community property during my time of my marriage. Right? But that my spouse may have thought that, or I may have thought that, and then I pass away, and my blended family may have a certain feeling about that. Right? And that's a conversation that you need to definitely be looking at, sitting down with your estate planning attorney, making sure that your separate property is designated, your community property is designated. Normally this would be done in like a prenup, but a lot of times we try to do this on our trust schedules to ensure that it is appropriate and proper. Payable and transfer on death. So that is similar to a beneficiary designation. Right? I can have a bank account that says, and a lot of times you may have seen this, that says TOD or POD. Right? If I pass away and I name my cousin as a payable on death beneficiary, it doesn't matter that I have a trust. I could have a trust with my house, my investment accounts, and all other cash accounts, and then I have this account sitting over here that says Mark O'Brien, POD, ABC, right? And that person, ABC, will receive that account. And a lot of times people will meet with their financial advisor or the investment bank or their cash accounts, and they'll say, sure, just name a beneficiary. Sure, just name a transfer on debt. And maybe at that time, I wanted that individual to be that. But what happens 5 years later when my mind has changed? What happens when that person's passed away? Right now, all of these circumstances matter, and maybe this account is now subject to probate because it was a transfer on death rather than titled in my trust, or rather than naming my trust as the payable on death beneficiary. So these are all conversations that you need to be having with your estate planning attorney because you can avoid it potentially and meeting with us and having to go probate. You want to jump in?
We had a file one time where mom has 3 kids and 2 daughters and a son, and the son was kind of wayward and the son was really not involved with the family, and it was kind of like one of these things where it was like, Mom, I hope you die, give me my inheritance type thing. Well, because of the relationship or the severance of that relationship, she came in and she did a will and she named her daughters as the beneficiaries under her will. She didn't think she needed a trust or anything, and so she changed her will, made it a daughter, but she had life insurance policies. Guess who was named the beneficiaries of the life insurance policies? All 3 kids. So what Mark's going over is things like transfer on death and things like that. It's very important. You can't ignore them, right? You've got to look at that stuff. Just because you set it up one time and put all those beneficiaries there, that may not be the way that it has to happen. Now, my preference on all of these things, entitling, I'll give it back to you here in a second. Is everything should flow through the trust. Everything can flow through the trust. So because you heard earlier about, hey, if I have a retirement account, you can have language in the trust that allows the retirement account to be a beneficiary, the trust to be the beneficiary of a retirement account, to be able to go to the beneficiaries and still maintain the tax deference, whatever it is. So you have the capabilities within the trust to do all of that stuff, and the preference would be everything flows through the trust. Because how do I know that the beneficiary is going to be healthy at the time I die, if it's mine? Right? How do I know what circumstances that beneficiary is going to be under? And if it goes outright to them, well, maybe that person needs a conservatorship, but if I can keep it inside the trust, then now my family is able to manage it without court intervention.
And to kind of piggyback off on that, for the beneficiary designation, most of you are familiar with that, with the IRA, 401k, right, retirement plans. Most of the time, you will see that you have named individuals as the beneficiary of that retirement plan. But like James said, what happens if that individual is passed? What happened to individuals receiving state or federal benefits? Did you just disqualify them from those benefits? If they've passed, is it going back to your estate, which now you have to go file a probate, right? So you can name the trust as the beneficiary, or even a backup beneficiary, depending on your circumstances, and that kind of catches all of that, right? But you have to meet with your financial advisor, have to meet with the estate planning attorney to make sure that your trust has the appropriate language to be receiving those retirement assets. For LLC, I'll kind of briefly go through this, but we always want to make sure that the member ownership, right, who actually owns the LLC itself, is your trust. If you as an individual go create a business or any entity and you name yourself as the owner, which normally that's the case, and you pass away, that is also subject to potential probate. And there are certain things you have to do to make sure that you're transferring title into the trust, and once we're administering it, and we're actually making distributions, that we're following the guidelines of that entity. Same thing with corporate partner ownership. I'll kind of skip through that. Custodial accounts, very similar to beneficiary designated accounts, but those are really for minor children who have a custodian or a guardian who own title. Ensuring that those are done properly is of paramount importance.
No, you can
Okay. So this is kind of along with what I just talked about. These are the various accounts that are applicable to all of those different types of ownership. So financial accounts, those are really just your standard brokerage or investment accounts, right? Your non-retirement accounts. A lot of times those are in your individual name, or your investment advisor will say, hey, just name a beneficiary. Or if it's the both of you, you and your spouse, they won't even give you a beneficiary form, right? What if something happens to you from incapacity? What happens to one of you for death? What happens to one of you if there's a divorce, right? All of these things matter, and making sure that you have them in your trust, again, having titling it in the name of your trust is important, because when they meet with us, and it's not in the name of the trust, we have to now go through whatever other process there is to make sure that it's being distributed to the heirs appropriately. And we may have to go to court to do that, and the court may say something different than your trust, okay? For retirement accounts, we kind of just talked about that, so I'll kind of briefly go through that. Usually that's in your name as an individual, and you're going to be naming that beneficiary. So it's important to be naming the trust, to making sure that your trust has the appropriate language in there. For real estate, that's again another thing that Coke & Barber normally takes care of that, right? When you come to us to create an estate plan, we transfer your title into the name of the trust, and then we will walk you through kind of what James talked about earlier. If a spouse passes away, you're updating the land records to remove them, but it still remains within the trust. When the second spouse, when your parent passes away, your loved one passes away, right? It's still in the trust. So we are helping you with the trust administration, everything that has to go through that. Life insurance policies, right? Very similar to, I would say, retirement accounts. A lot of times you just name a beneficiary on that life insurance policy, right? But you have a choice to name the trust as the beneficiary. And then again, that encapsulates any situation where that individual, if I've named I have a 9-month-old baby boy, if I name him as a beneficiary of my policy and I pass away, is that going to be problematic? Well, absolutely, right? So instead of doing that, I name my trust. My trust has all kinds of provisions for who's going to be his guardian, for how to take care of him, for how to spend those money, and who can actually manage that money, right? As opposed to the state of California having me go file a guardianship and telling me what I'm going to be doing. I'm the one who's dictating and controlling that. For business interests, kind of similar to what we just talked about, making sure that the actual ownership of the business is applicable. Personal property, a lot of times we'll just do a general assignment for personal property. We're not going to tell you, your estate planning attorney is not going to say, hey, go title your refrigerator in the name of your trust. Right? That's not possible. If you do that, I have other questions for you. But yeah, normally we just do a general assignment for the personal property, but making sure that you're inventorying it, making sure you're taking care of it, and then your estate plan, making sure that you're designating who you want it to go to. If you do not care, and you just say everything goes to my spouse, that's okay, right? But if you have a specific antique or jewelry or something from your family legacy that you want to go to a specific person, we need to be designating that. We need to be saying that. Otherwise, as you all know, and as James is a perfect example with his siblings, right, you're going to fight over it. You could have a $20 million, I've done litigation for $50, $100 million estates, and most of the time, they're not fighting over the $100 million business. They're fighting over a $20 piece of sentimental personal property. And that's just how it goes. And they spend $500,000 of legal fees over this piece of $20 inanimate object, right? So making sure that you're having these conversations, you're aware of that, and specifically designating that can kind of, keep the siblings at bay, keep your family members at bay while they're going through this hard process. And then finally, digital assets. This is something you want to take care of, whether it's cryptocurrency, whether it's online social media accounts, right? It used to be that if someone passed away and someone tried to get into your Apple account, it was almost next to impossible. They would tell you to go get a court order, right? And how to get that court order was in flux and very vague. We didn't really know how to do that. But nowadays, we take care of that. We put a lot of that in the trust. And basically, each type of digital asset, kind of walking through that process.
And so as you can tell, as far as this part of things, it's all about who owns it, right? It makes it the most efficient. I will say my dad had a very good advisor on titling all of his assets because everything was either in the trust or directed to the trust. And so, so from that perspective, it's making the administration a lot easier. It's going a lot smoother. There's the two main things that slow administrations down, and which, if it slows the administrations down, it's usually causing legal fees to go up. And I'm not opposed to that, all right? But suffice it to say, if you want it done efficient, have everything titled the right way, owned the right way, and that's something you can do. The other part, you don't have any control of because that's about the beneficiaries. And that's their relationships with each other and how they trust each other and how much they're going to fight. So, and like I said, there's going to be, you're never going to get around hurt feelings. You're never going to get around, the differences between siblings, but that's just the way it goes. And that's always going to be there. But you can make it a lot easier on your trustee, on your sole trustee, one trustee, okay? If everything is titled correctly and directed, either titled in the name of the trust or directed at the trust. And again, if you've had a trust that's, let's say, more than about 5 years old, I would say, and you want your IRAs, your retirement accounts and stuff like that directed towards the trust, you need to have an appointment, make an appointment, come on in, see if that language is in there. Because from my perspective, and I think I can speak for Mark as well as Megan, it'd be a lot easier if everything is directed to the trust and distributed through the trust rather than individually. Because there's just so many more protections under the trust if something should happen to one of those beneficiaries, and you didn't have time to come in and make those adjustments to the trust. And I say that with, I've got two sisters who are special needs, and so we're dealing with that. One of them became special needs after my mother's death, and so I can't do anything with her part of the trust. But there are provisions in that trust where I'm not giving it to her. We're still keeping it inside the trust because we have the permissions inside the trust to do so. So for me, having things directed to the trust is utmost important as it relates to funding. Well, that's all we got. I will say I'm a little miffed, though. I never got a public announcement of becoming a partner, by the way. And so somebody here gets a public announcement.
James, you are now a senior partner.
And so I'm going to bring up partner, Victor Raymond.
Thank you. He likes to make me blush is really what that just came down to. All right, so this next section, defending legacies. This is litigation. Basically, if you don't listen to us, you don't take our advice, you do it your own way, unfortunately, odds are you or your estate and your beneficiaries will wind up in litigation. And I say that semi-facetiously, but it is really true. Estate planning is one of those areas that people, other even attorneys that don't do this, they assume it's easy. I'm just putting something in writing of what I want to have happen when I die. The problem is it is not that easy. It is one of the most complex areas of the law. This is used if people can't sort stuff out on their own. Litigation comes into effect when you've passed away, or you may even still be alive but incapacitated, and people are not able to agree, they cannot have a meeting of the minds, and unfortunately, now we have to get a court involved. One of the things, and James often hits this, is think about your kids when they were younger, especially if you had more than one. Did they ever fight over toys? Most of the time the answer is yes. Sometimes they would physically even fight over toys. When you have young kids, you're the referee as the parent. It's your job to figure out, sort it out, make sure that they can move forward. Once you're gone, unfortunately, those fights often escalate because now they're grieving, now there's sometimes sizable amounts of money involved, now there's emotional treasures like Mark talked about, and again, you can't mediate any further. So now we have to ask a judge to do so. A judge who doesn't know your family, didn't know you, is really just there to be practical, logical, get it done and get it out of the court. And that can have catastrophic consequences on, yes, the estate value because you're paying attorneys, you're stuck in court, but really catastrophic occurrences on the emotion of the family, on the unity or lack thereof at that point of the family. So there's a number of issues that you're basically asking to walk yourself into litigation or walk your family into litigation. Poorly drafted or worded documents. Our job as estate planning attorneys is to avoid that one. Our job is to make sure that what you're communicating as your intent is accurately caught on the page. Because it's very easy to come in and say, I want to leave my property, let's say you're going to leave it to a child who can live in the property for their lifetime. You don't want to distribute it. We've had this happen where there can be kids who are special needs, as was just talked about. So you say, I want my special needs child to be able to live in the property for their lifetime. The rest of my estate is going to go to the other kids. Okay, that's great. And if you just put that on paper, you have litigation. The reason is you said my estate's going to my kids, but my special needs child who can't work, who has no income, is living in the house. Who's paying those property taxes? Who's paying for the maintenance? Who's paying if there's a mortgage? You just distributed the rest of the money. So it has to be properly built out to make sure that, hey, what is the intent? I want my special needs child to live in the house and I want the estate to pay the property taxes, the mortgage, and the maintenance until their life ends or until they no longer reside there. Then this is what's going to happen. So it's building in these layers, it's building in those contingencies, it's looking at the whole picture that a lot of times doesn't get done with the DIY trusts or the frankly cheap trusts that get sold for the $200. They're taking what you said at face value and plugging it in. And then our attorney Elaine comes in and has to argue with the court what we think was the actual intent. So making sure you really do have the quality behind it is huge. Incomplete documents. So this can be people who are trying to rush get something done. Unfortunately, when you wait to plan until there's an emergency, corners often get cut because you're in an emergency situation. So you tackle the immediate problem, but you don't tackle the what comes next component. Again, that has to be answered at some point, and if you are no longer here, the judge has to help answer that question. Out-of-date documents, we've talked a fair amount about why it's important to come up and keep your documents updated. You went through a divorce, you've now passed away, you never updated your documents. Well, your ex-spouse may be still your beneficiary in the court sides. The family may go and fight that, your new spouse may go and fight that, but it has to then be fought. Keeping your documents up to date cuts that part of the fight out. It ensures that your current intentions are actually captured to eliminate the fight. Now, the reality is, especially with this last one, we cannot stop somebody from fighting. We can stop them from being successful in that fight. When somebody passes away, grief and greed, those are two of the strongest emotions and powers, and they come slamming into each other. In even the best of families, grief and greed have powerful division powers. And it is again something we seek to avoid on the planning side, but it is not something we can 100% remove. But again, with proper planning, you can, for one, disincentivize people from fighting. With Copenhagen Trust, we put a contest clause in. We say if you go to fight and you have no basis of doing so and you lose, you are disinherited. You lose. You're out. You don't get $1 for the soda, you get nothing. It's a huge incentive for people not to fight. But again, with proper planning, with the language, you can also ensure a lack of success. But I can unfortunately, very personally speak to, after my grandma passed, I have a family that is probably your typical family. We're not perfect, you know. And one of my grandma's children decided to fight. He did decide to go to court. The attorney my grandma used had not put in a contest clause. She had also, unfortunately, modified my grandma's trust in a way that was inaccurate. She had misnumbered, mislabeled paragraphs, and effectively had disinherited one of my grandma's kids. I'm not naming names because this is live streamed, so being vague for a reason here. She only had 2 though. That was a nightmare. That was an improperly drafted document. It's a family where one of her children is unfortunately very greedy. He's also a very hurt person, if we're being honest. He's got his own emotional things. Shouldn't have said his. And it led to fights for years, and I was her trustee. And so I had to go into court and deal with the logic and the emotion. And for my grandma's other child, that was a nightmare. She didn't want to fight. The inheritance is being depleted, all for something that, frankly, with proper planning, could have at least been mitigated. Maybe not avoided, but certainly mitigated. So quality, we will stand behind that 10 out of 10 times. Now, who do we actually represent? So the trustee that comes and talks to us, we're representing the trust, and as a result, the trustee who is then tasked with defending that trust, if a trust was had. Now, if there wasn't planning, again, that's probate, it's a different conversation. But with trusts, we're there to help defend that trust and make sure your intent is actually carried out. That becomes our job. Now, we can also represent beneficiaries, not in the same case, but we can represent beneficiaries as well. When you set up your trust, we encourage you to choose trustees that you trust. That word is used all over the place in this area of law. But sometimes people change. Again, grief and greed come into effect. Trustees have their own lives, so when you pass away, they may have something else going on that distracts them, that makes them act not consistently with what the trust is instructing, with what the law is instructing, and sometimes they flat just don't want to. I'll say there are unfortunately some trustees that start having some self-interests. We can also represent beneficiaries to ensure that their interests are protected. So depending on which side of the coin it is, we can represent both, but again, not in the same case. All right, this next section, the beneficiaries, this is somewhat of a duh moment. People who want their money, they can be impatient. And I say their money somewhat sarcastically. One of the issues we see is people become very entitled when they believe they're receiving an inheritance. And that entitlement sometimes has a bit of foundation. Maybe you are actually written into the trust. Sometimes that entitlement has absolutely no foundation. But people start to chomp at the bit as soon as someone passes away about where's my money? I want my check tomorrow. I need my inheritance immediately. That can put an extreme burden on a trustee, and unfortunately at times beneficiaries will go so far as to try to claim that that trustee is acting too slowly, and they'll go to court to fight that. What I'll say to beneficiaries, if you're in that position, have some patience. If you're really concerned, talk to a lawyer first who can hopefully counsel you well. But a lot of times administrations are slow. There's a lot that has to be done, and the beneficiaries don't understand that. And again, they get into this mindset of, I'm entitled to that check the day after the person passes away. And that is not the reality. You also have beneficiaries that are unthankful, they're ungrateful, they think they didn't get enough. A lot of times, unfortunately, we hear, I was the one who took care of mom, so I deserved more. You can have those feelings, but the reality is, if it is in a trust, that is that person's intent, and our job is to make sure that that is carried out. But those hurt feelings can overshadow every other component, and again, people will go to court over it. Unresolved conflicts. If your kids did not get along as children and never figured it out as adults, it does not get better after you pass away. Again, grief and greed. They really are some powerful things. Now, trustees, if you are in the position of being a trustee, you have an extremely high duty in that role after you officially become the acting trustee. You need to, James, Mark, Megan, they are the people that you would want to turn to as a trustee to make sure you are doing your job correctly. Because again, it is a job. This is not something to take lightly. But the good news is when you work with a qualified team, that team can take a lot of those burdens off of you and ensure you're doing the job adequately to ensure you don't get sued. But some trustees will do a DIY situation. They'll say, oh, this will be easy. I'll just settle it on my own. But they don't understand. You have a duty to inform those beneficiaries. You have to do so often very timely and probably more frequently than you would potentially like. The trustee may just flat not be competent. There are people who, and I don't mean legally incompetent, I mean if you have named somebody who can't manage their own finances, they're in constant debt, they can't pay their bills, do not name them as yours. It will be a problem. Now, you don't need somebody who has a master's in bookkeeping or any of that, but it needs to be somebody who has general competence of, again, paying bills on time, and frankly, knowing what they don't know, knowing that they need to ask a question instead of guessing and trying it on their own. People just flat not doing the job. If you have a trustee who steals, you frankly should at that point be brought into court. That's where we absolutely want to represent the beneficiaries to make sure that somebody stealing from an estate does not get away with that. That one's a cut and dry. And then trustees who influenced, basically if you had a trustee who influenced you to update a document, you were no longer competent, they brought you to an attorney, who would not be us at that point, they brought you to an attorney who is willing to change a trust despite you being incompetent. Again, that is where we absolutely will represent a beneficiary to ensure the intent you had while competent is the intent that actually gets carried out. Not the written word after they influenced you, but you no longer have legal competency. Again, that's where we absolutely want to make sure beneficiaries have their day in court. So types of cases we handle, it's a laundry list. Essentially what I'm going to say on this is, if you're already in the midst of court and you don't know if you have adequate counsel, you flat don't have counsel, come and talk to us. If you are concerned that you think court or litigation is impending, come and talk to us. If you have a few questions about a litigation that already concluded and you're concerned about the outcome, you can even talk to us on that to make sure that things really are done correctly, competently, professionally, all of those things that we stand behind. Because estate planning you do not want to do on your own because of everything that can go wrong. Administration you do not want to do on your own because of everything that can go wrong. And litigation you certainly do not want to do on your own because there are so many rules that need to be followed. And most of us would not have the time, energy, or know-how to do it on our own. We also can help you in other litigation areas. So a lot of what we talk about is how litigation ties into estate planning itself. But Catherine mentioned a few times on the business side, on the tax side, the litigation components. Elaine is extremely well-versed in the law across the board. But she's also one of those attorneys who, again, knows what she doesn't know and has a network of other people that we can help you find if we cannot directly help you with that litigation case. So if you're at that point of, I just need a turning point, I need to talk to somebody who can get me to that next step, do come and speak with us. But truly, our goal here is to avoid court, whether that be conservatorships, probate, end-of-life litigation, whatever that is, our goal here is to not have you wind up there, to not have your family wind up there. Pre-planning, proper planning, these are all of the different ways to help ensure you can avoid litigation. Again, we cannot guarantee it's avoided. People can sue, as I said, whether we like it or not. But at least with proper planning, it helps cut out the odds of it, and certainly will cut out the odds of somebody being successful where they should not have been. All right, we warned you that this was going to be a lot of information in truly a very short amount of time. If you need to see this again, the good news is it is live streamed and will be on our YouTube channel. The other thing is if your spouse couldn't come, your kids, your grandkids, your friends, please feel free to have them watch these live streams. We also, as has been mentioned, have QR codes throughout the packet. We have online resources. We have a ton of material to ensure that people have access to these education events and then can come in and meet with us. So we very much appreciate any of those referrals, because if you've put your trust in us and trust us enough to have someone else come work with us, that is one of the best compliments and gifts that you can give to us as attorneys. Now, a couple of just housekeeping bits before I turn it over to Lloyd to wrap us officially up. If you sign up for an appointment, make sure that you get a questionnaire. It can either be handed to you or will be emailed to you. The reason those questionnaires are important is for new clients, it lets us get a quick snapshot of what we need to address. But for existing clients, it will ask what appears to be some redundant information. But that is information that helps us really see in evaluating what you've done versus where you're at today. Are there key points we need to make sure get addressed? So fill it out to the best of your abilities. If you're not ready to actually sign up for an appointment today, you'll see the green sheets, hopefully, that were with your packets. Those are there for a few reasons. One is going to be letting us know how we did. It is crucial for us to know how this was for you guys, because we want to make sure it's really beneficial. But it also is where you can note, I need a phone call or an email to schedule an appointment at a future date. I'm not quite ready, or these dates didn't work for me, so please reach out. We have the appointments for estate planning. If you need to meet with business and tax, lifestyle, litigation, trust administration, you can also note that specifically on the green sheets as well. With that, thank you. I'm going to have Lloyd just say a quick closing word. We very much appreciate, for those green sheets, there will be people at the door. Caitlin is waving to you so she can be your maid to collect them. Thank you so much.
Thank you very much, Victoria. Well, did I exaggerate about the new team? I thought they did an absolutely fabulous job. Let me say a couple of things. We'll get you out of here. This will be a record for Colton Garter. You're going to get out of here before noon. First of all, I want to emphasize as strongly as I can the access thing. Because when that change occurs, it will be detrimental for anybody who tries to join thereafter as opposed to joining now. And so be sure and talk to Chris. I'll be out there with him to answer questions on that access program. My concern is not about the access program. It's a concern that those of you who have been clients for many years and who have questioned whether you ought to do it or not have an opportunity to make sure that you're included under the original program so that you're protected under that program, because it is real protection. The other thing I want to say is I made myself a promise many, many years ago. I had a situation where I was attacked, and it was a serious attack. It made the front page on the Los Angeles Times. And I told my wife when I saw that newspaper, I said, we'll be fortunate if we have any clients at all after they read this article, because if I were a client and accusations were made like that against my attorney, I wouldn't take a chance on whether it's true or not. I would protect my family and get away. Amazingly, only 7 people asked for their files. Of that 7, 5 asked to be reinstated when I was cleared. And I said to myself, I will never be in front of my clients without telling me how much I appreciate you. You were there for me when I needed you. You have brought pleasure in my life just getting to serve you and see your families grow and see your circumstances change. It's amazing. I was talking a while ago about the large estates. You can't imagine how many of the people that started out with me 45 years ago, who didn't have a pot or a window, who are multi-millionaires now. God has blessed them. It has been wonderful to watch that happen. It's been wonderful to watch children grow up and become parents themselves with grandchildren and great-grandchildren. And so I want to thank you all for the privilege of serving you all these years. May God bless you. You have a wonderful rest of the day. and we'll love to see you again in the future.